Can you talk a little bit about the change there and the move from, 3.156A, new and material, to new and merely relevant?
Yes. The change from new and material to new and relevant, in my experience in dealing with the VA, isn't really a huge change. The reason for the change in the wording is that there was concern when the Appeals Modernization and Improvement Act, known as the AMA, was being formulated, that the standard for new and material evidence was too high. And that was a concern that was being pressed by a lot of the veteran service organizations, Disabled American Veterans, American Legion, Paralyzed Veterans, etc. So there was a lot of back and forth about that. There was a lot of back and forth about various provisions in the AMA, but this particular one got a lot of back and forth. And ultimately the compromise was that they would change the language from new and material to new and relevant, with the thought that was supposed to establish a slightly less difficult standard for veterans to meet, to show that their claim should be reopened because of new information. I have to say that in my experience, it hasn't made what I would consider a huge difference. I mean, I think the standard in practical terms has been pretty similar, maybe a little lower, but there hasn't been a lot of change.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Tony Francis Jackson.
Welcome to Victory Over VA. If you're a veteran struggling with the VA's disability system, or just want to make sure you're getting the benefits you've earned, you're in the right place. Don't forget to hit subscribe so you never miss an update that could change your life. I'm Christian Terrison, here with renowned veterans disability attorney Francis Jackson of Jackson and MacNichol. Jack has dedicated his career to helping veterans like you win the benefits you deserve, recovering millions of dollars for thousands of heroes. This podcast isn't just for veterans navigating the system, though. It's for their families, their friends, and anyone else who wants to stand shoulder to shoulder with those who served. So stick around, because we're here to make sure you get the support you need. Now, today's episode is going to be a bit of a complex and nuanced one, to say the least, which, no surprise when we're talking about the VA disability system. But we're focusing on a change in reopening old claims, and specifically the type of evidence that is needed when you're reopening old claims. And this is in the Code of Federal Regulations 38 CFR 3.156 is the section. Can you tell us a little bit about what that section covers and what it means in plain English?
Sure. There are actually some subsections to 3.156, but the one you're talking about with new material evidence is under 3.156A. And what that does, I'm never sure how best to come at this, but in ordinary legal settings, generally speaking, you only get one chance to prove your case. So say, for example, you get hit by an automobile and you're injured, you go and have a trial, there's a verdict, it's not appealed. Whatever that result was, that's typically final. You don't get to go back 2 years later and say, hey, I want a do-over. I didn't like that result, I want a do-over. The VA in 3.156A has created an exception to that rule that we generally think of as legal finality. What 3.56A says is, okay, we recognize that the VA system is not perfect, and that there may be times when we didn't get it right the first time and you really should get a do-over. So what 3.56A lets you do is, now keep in mind this is in the legacy system, the older claims, and there are some nuances about that in terms of the current system. But anyway, 3.56a, and it's a legacy version or relationship, is designed to let you say, okay, I have this new evidence that you didn't consider before, and I want you to re-adjudicate my claim because this evidence is new and it relates to the reason why you turned down the claim. It has to meet both of those standards. So it has to be new in the sense of literally having considered it before, and material, meaning it's related to the reason why you got turned down. So not all new evidence would qualify. You know, if you had new evidence that there was an accident and you were hit by the car, that wouldn't necessarily change anything because it was already agreed and understood that you got hit by the car. But in our VA context, if you could now show that this was during a time when you were in service, then that would change things if the VA had previously thought that this accident occurred before you were in service.
So are there time limits on reopening a claim using that provision?
No, there are none. That's what makes it so important and so powerful. And you can do it multiple times if you find other pieces of new evidence.
So what, in the context of a VA disability claim, what types of evidence are most common for qualifying as new and material? Are we talking strictly, old records that for whatever reason were thought missing or not part of the case, or, and therefore not considered and new to the case? Or is it, new evidence created by a medical expert? What?
Well, it can be really any of those things. Most commonly, it's what you just touched on, which is new medical evidence. And for a couple reasons. One reason is that medical science continues to evolve, and we learn things that we didn't know that simply the science didn't exist at the time of the prior claim, and now we know that A causes B. We didn't know that. So that's kind of one sort of thing. Another variant on the medical issue is a lot of times VA claims are turned down because of the lack of a linkage. Remember, in any VA claim, you have to have a current medical condition, you have to have some kind of event in service that was causing the condition, and you have to have a medical opinion tying those two together unless it's a presumptive condition. So what often happens is that a veteran will make a claim and either will not have the medical evidence tying his condition back to service, or he'll have medical evidence that's weak or generic. The doctor will say, well, yeah, you had high blood sugar in the service, and that might have been an indication that your diabetes started then, but we really don't know. That kind of sort of wishy-washy stuff. Whereas a specialist in diabetes might come in and say, well, given these blood sugar findings in service, we know the diabetes started right then. So that kind of thing is relatively common. There's another provision in 3.156 in C that allows for reopening a claim based on military records that were not in the hands of the VA at the time they made the initial determination. But there's an almost infinite range of what qualifies as new and relevant evidence. It just has to be new and related to the reason why you were turned down.
So you mentioned earlier about this regulatory provision and how things have changed with AMA. Can you talk a little bit about the change there and the move from, 3.156A, new and material, to new and merely relevant?
Yes. The change from new and material to new and relevant, in my experience in dealing with the VA, isn't really a huge change. The reason for the change in the wording is that there was concern when the Appeals Modernization and Improvement Act, known as the AMA, was being formulated, that the standard for new and material evidence was too high. And that was a concern that was being pressed by a lot of the veteran service organizations, Disabled American Veterans, American Legion, Paralyzed Veterans, etc. So there was a lot of back and forth about that there was a lot of back and forth about various provisions in the AMA, but this particular one got a lot of back and forth. And ultimately, the compromise was that they would change the language from new and material to new and relevant, with the thought that was supposed to establish a slightly less difficult standard for veterans to meet to show that their claims should be reopened because of new information. I have to say that in my experience, it hasn't made what I would consider a huge difference. I mean, I think the standard in practical terms has been pretty similar, maybe a little lower, but there hasn't been a lot of change.
Gotcha. And now, as an attorney, when you're looking at a veteran's claim as it comes through the door, are you looking with an eye to see if there's evidence as part of that claim, or if the claim references evidence that may exist but was excluded with this provision in mind for reopening the old claim?
Sure. In any case that we take, one of the things that we do is to get the VA's entire file and to review that file and look at any claim that has previously been closed. And those claims can be closed one of two ways. They can be closed because the VA said, oh, this isn't connected to service. That's one possibility. The other way it gets closed is the VA says, oh, yeah, okay, we think that was connected to service, but we're going to give you a non-compensable rating saying that it's service connected at 0% or 10% or whatever. And the veteran believes that his condition is more serious than that and there should be a compensable rating or a higher rating, whatever it may be. But the process that we go through in every case is to look at every closed claim and try to determine whether we think the claim has merit and we should be asking either for service connection or for a higher rating, whichever the case may be.
And then how can 3.156A make the difference between, sort of a modest increase versus significant back benefit payments?
Well, it all depends.
It always all depends.
It always all depends. But for example, I was looking at a decision that came in within the last month, I don't remember what day, and they raised the veteran on this new claim. They call it a supplemental claim now under the VA, where you submit new relevant evidence. They raised the veteran's rating from I've forgotten now whether it's 20 or 30%, probably 30%, to 70%, which is a big jump because the benefits don't increase arithmetically, they increase geometrically. And so a jump from 30 to 70 is a pretty big deal. But, you can never tell just looking at the cold record before you talk to the veteran what has changed since the initial claim was either denied or given a low rating. But sometimes, on a supplemental claim, you get a big increase. I mean, we've seen supplemental claims where people jumped right to 100%.
So for a veteran who might be watching, who thinks they have a claim, a legacy claim where 3.156A might apply, what should their first steps be in that instance?
Well, keep in mind that most legacy claims have been resolved. There aren't a lot of these still kicking around. But if you are unlucky enough to be a veteran who still has a legacy claim out there, the key thing you have to look at is what was the reason that VA gave for turning down the claim? Because to get evidence that's new and material, it has to focus on that reason why the claim was turned down. And at this point, the only ones I'm seeing with any frequency are ones where new medical evidence is the new and material evidence. I've had claims over the years where there was factual evidence that was missing and we were able to develop buddy statements and that sort of thing. But I'm not seeing much of that at this point. Most of the legacy claims that are still out there are ones where it's really the medical connection that's being fought about.
And just for a quick reference, the cutoff for legacy versus the Appeals Modernization Act was that February
19th of 2019. And so any substantive decision issued after that, decision on the merits as opposed to a continuation of the prior denial is going to be an AMA decision and appealed in that setting.
Yeah. All right. Well, that's our episode for today. Thank you for tuning in and joining us. Please be sure to like and subscribe. Watch again next week.
Thank you.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.